All rise. Hear ye, hear ye, hear ye. The Court of Appeals of the State of Kansas is in. Proposed Sarah E. Thank you very much. Welcome. Please be seated. Good afternoon and welcome to the February 2025 oral arguments before the Kansas Court of Appeals. Before I call this afternoon's docket, I thought I'd take a few minutes and introduce the panel of judges before you. To my right, your left, is Judge Catherine Gardner. Judge Gardner is from Topeka and has served on our court since 2015. And before that, she had a career in private practice and worked for many years in the chambers of a federal judge. And then to my left, your right, is Judge J.C. Hurst. Judge Hurst joined the court in 2021, hails from Lawrence and had a private practice career and an in-house counsel career in Kansas City. And I'm Sarah Warner. I will be presiding over today's docket. I've been serving on the court since 2019, came from private practice in Lawrence and live in Lenexa. So it's good to be with you. We have two cases on this afternoon's docket. We, as the panel, have thoroughly read all of the briefs, gone through the record. We have reviewed research memoranda prepared by research attorneys. And so we are very familiar with the facts of the cases. And so I encourage you, we have 15 minutes, just jump right in to the legal arguments, just so we use our time wisely. Both cases this afternoon have been scheduled for 15 minutes of argument. We are trying something new and also very old and using this. So to work with me as I'm learning this, let's just say classic technology. But along those lines, if you're representing an appellant, be sure that you request anytime you want for rebuttal. With that, we turn to the cases that we'll be hearing this afternoon. The first case is 126981 from Jackson County, Theodore James Purdy versus State of Kansas. The council may please approach council table.
Jonathan Sternberg for the appellant.
All right.
I don't see my opponent.
I also do not see your opponent, but for that, you're welcome to present any argument that you have.
Certainly. Thank you, Your Honor.
In light of that, we don't need to worry about rebuttal.
I guess not.
Okay.
I'm not used to the state not responding to or not coming to an argument for a criminal case. Frankly, I think that takes us a little unseriously, and I hope the panel will entertain me nonetheless. I'm Jonathan Sternberg, and I represent the appellant, Theodore James Purdy. He goes by James. As Your Honors know, I won't belabor the facts, but Mr. Purdy was convicted of rape and aggravated indecent liberties and was sentenced to a hard 25 life sentence. He now appeals the partial denial of 60-1507 relief. And
I just wanted to be clear on that,
Yes.
counsel, that the district court did grant relief in terms of a new trial for the indecent liberties.
That's correct.
Conviction, but not for the rape conviction.
That's correct. Although we're kind of on our issue also here on the indecent liberties about the corpus delicti part. Because in our opening brief, we asked the court to actually reverse and order Mr. Purdy discharged completely. Because if the the issue, the third issue, the third claim for relief goes to both the aggravated indecent liberties and rape convictions. The district court certainly granted him a new trial on aggravated indecent liberties, but it didn't discharge him. And that's one thing we asked for, obviously, in the alternative. But to get to the meat of this, what the district court did is on the third claim, which is trial counsel's failure to object to inadmissible hearsay from the alleged victim, A.L., that came in through a detective. And I realize his name looks like Montague, like in Romeo and Juliet. It's actually pronounced Montag. So Detective Montag's testimony, as well as possible statements by him in State's Exhibit 1, which was the video of Mr. Purdy's interview. The district court agreed with us that this was deficient performance. In fact, the state had conceded this below. I know in their brief, they now go back on this and say, well, actually, no, it wasn't deficient performance. I don't think they have the right to say that for the reasons that we mentioned in our reply brief. But more importantly, and this is a little awkward, after the evidentiary hearing, we had an argument session by Zoom with Judge Ward. Judge Ward was down in El Dorado because he was a special judge assigned to this, and opposing counsel and I were in our respective offices. That was not actually transcribed. I wish it had been put on the record, but there, the state's lawyer conceded that this was deficient performance, and Judge Ward notes that in his judgment as well. So I just want to mention that for the record. But then Judge Ward said that this wasn't prejudicial, and that's what we're here about. Holding that the failure to object to this inadmissible hearsay wasn't prejudicial was error. And to begin with, Judge Ward, we'll start at the beginning, the real problem here is he held this wasn't hearsay. It most certainly was hearsay.
Do you agree that this issue turns on that fact, whether it was admitted for the truth of the matter asserted?
It turns on a couple of facts, but that's one of them, yes. Although I don't know if we'll start out with truth of the matter asserted, because this is testimonial hearsay, right? This is testimonial hearsay at the outset. So whether it fits traditional hearsay rules or not doesn't really matter.
Step me through why it's testimony.
Sure. So under Crawford, any statement made to law enforcement to investigate the crime that the defendant is charged with is testimonial.
Is that the case when you're talking, this is about hearsay within hearsay, and the original hearsay statement, if it was in fact hearsay, was a statement by the girl to her grandfather?
Actually, no, Your Honor. So, and I think there is some confusion about this in the record. So it's, bear with me. So it's record volume 10, page 125, is that the AL, the alleged victim herself, responded to the Eudora Police Department with her grandfather, and she made statements, according to Detective Montag, to the police herself. It wasn't just the grandfather. The grandfather reporting it's not enough. And Detective Montag also says, it's pages 129 to 130 of volume 10, is the trial transcript, that one of the specific details that she was complaining that he had inserted something into her. So no, it isn't just hearsay within hearsay. This is actual hearsay. Crawford itself was a similar situation, although not a sex crime. It was a violent crime instead, where the alleged victim went to a police station, made this statement to police, and then a recording of it, and I think the officer's testimony, were going to be admitted, and the U.S. Supreme Court said you can't do that. On page 19 of our opening brief, and I'll note the state has no response to this at all either, we cite several cases from throughout the country where in similar sex crime cases, statements like AL's to law enforcement was also held to be hearsay.
So would that though be limited to Jane's, I'm gonna go with Jane's statements to law enforcement as opposed to grandfather's statements to law enforcement?
Yes, because that's what Detective Montag was testifying about was, sorry, go ahead.
No, I'm sorry. So any statements that the detectives made regarding grandfather's statements, you would concede are not testimonial?
No, I'm not conceding that at all. I don't think they're at issue.
Okay.
I don't think they were made at issue in the case because the question was what corroborated my client's testimony, my client's alleged statements that he was trying to get thrown out, as well as what the evidence against him was at trial. The evidence against him at trial was this hearsay from her. And I think it's important to remember the in the unusual importance of that in this particular case. Here, the trial court had held the alleged victim available to testify under 6417, and that any hearsay by her would be barred under 6460 DD unless she came and testified. So trial counsel said their main strategy was if she didn't show up, or if she wasn't going to testify at trial, that they would object to any statements from her as hearsay. And so it's really the statements from her that matter for this. And I don't know that there really are any statements from grandfather actually in the record, at least at trial. Certainly Detective Montag didn't testify about that, and it's not in the video. I do want to mention something about the video since the state brings it up in their brief. They say that because we don't know, and this was something that this court said on direct appeal, we don't know what portions were played for the jury. We don't know whether those hearsay statements from Detective Montag on that video were heard by the jury or not. That's a red herring in this case. If it was heard by the jury, then it's prejudicial. If it wasn't, then it's irrelevant. It doesn't matter. The question is trial counsel's failure to object and what the effect of that would be. The other problem is that, so just to go back, it is hearsay, and it's certainly testimonial hearsay that's barred by the Confrontation Clause. Judge Ward in his judgment doesn't really go into our Confrontation Clause issue at all. He simply talks about ordinary hearsay. And then in our, we asked him to reconsider because he had said, well, I don't actually need to, it's all speculation. We can't know what the courts would have done. And then in an order supplementing his original decision, he goes into this case called Araujo or Araujo from the Supreme Court of Kansas in 2007. That too is a red herring because the problem in Araujo was it wasn't statements to law enforcement about the crime with which the person was charged. There was no attempt to admit any statements by the person calling 911 to actually say that the defendant had committed the drug crimes that he was charged with in that case. So that's not testimonial hearsay simply because it has nothing to do with the case at issue. This is different. This is statements by the alleged victim about what the defendant allegedly did to her that are coming in through an officer. The state, though, also argues if this isn't testimonial and we're just talking about ordinary hearsay, the state also argues that this wasn't offered for the truth of the matter asserted. That's simply not true, and it's not reflected by the record. The state offered it specifically to the jury, and this is Record Volume 10, page 199, in closing argument. They said that the alleged victim's statement to law enforcement meant Mr. Purdy had, quote, corroborated what she had said. If that's not offering this for the truth of the matter asserted, I'm not sure what is. Also on direct appeal, and I know Judge Gardner, you were involved, you were on the panel in the direct appeal. The state argued, and this court agreed, and this is at page 11 of the opinion, that the corpus delicti was established through Mr. Purdy's statements because they were corroborated by these statements. Again, these aren't being used for anything other than showing, at least showing to the jury and then showing to this court, that there's evidence that Mr. Purdy had done what he was accused of. That is offering this for the truth of the matter asserted, and frankly, I think it's disingenuous of the state to argue otherwise now, having argued that to the jury before. That's also not something they argued below either.
Counsel,
Yes, Your Honor.
I want to put aside that, and I understand that this is one of the focus of your case, that is the corpus delicti argument.
Yes.
But I want to put that aside, and I wonder if you could just step me through the prejudice with regard to the rape conviction specifically.
Sure. So if we're getting to that point, we're first assuming that this was inadmissible. So assume for the sake of that argument, if it's prejudice.
That's great. So assume that we find deficient performance.
Right.
Just step me through how we get to the second prong of it.
Sure. So the only evidence against Mr. Purdy at trial were his statements to law enforcement that he then took the stand and testified about separately, as well as these detectives, Montag and Bridges' testimony of the statements that he had previously given, as well as the inadmissible hearsay. Absent the inadmissible hearsay, all you would then have are these conflicting statements, one from Mr. Purdy and one from law enforcement. And that's enough for the jury to have not agreed. If the jury had never heard or had been instructed to disregard statements by the alleged victim that Mr. Purdy had done these things to her.
But what about Mr. Purdy's own statement to the police with regard to his conduct and specifically the conduct that led to the rape conviction. That's what I'm looking at. Like if we were talking about the other conviction, then maybe this would have been more front and center. But here you have Mr. Purdy, who has specifically told the law enforcement that he penetrated this girl using his finger.
Yes.
Isn't that, and how do you get past that?
So, Your Honor, it's in Strickland prejudice, it's not a sufficiency inquiry. If I were arguing sufficiency of the evidence, that would be one thing, but we're not. This is about whether it's something that reasonably the jury could have gone the other way if it were that way. Mr. Purdy, yes, you are right about the statements he gave. However, he also took the stand and he testified that he was a Marine, a combat veteran. He had PTSD and anxiety, and that the statements on video weren't true. And he had been told by officers that he was just being given the good faith of the district attorney if he said he had done these things. And the jury, but for the statements about what the alleged victim actually told law enforcement, it's entirely possible the jury would have believed that. But the calculus was no longer the officer's testimony and his testimony. It was now the officer's testimony, his testimony, and the statements that the alleged victim made.
What is the standard? Is it that it's entirely possible? So in other words, there's a possibility, or is it something else?
Sure. So the Strickland standard is not outcome determinative. It does not have to be that it's certain. It's just that counsel's deficient conduct more likely than not altered the outcome. That a reasonable probability is a probability sufficient to undermine confidence in the outcome. That's right from Strickland. So it doesn't have to be outcome determinative. We don't have to show a lack of sufficient evidence. It's simply that if you're a reasonable juror sitting in the shoes here, this isn't a case of overwhelming evidence. It's not a case where there's videos and eyewitnesses and all of that who are coming in to testify. It's effectively a he said case between Mr. Purdy and the officers at that point.
Or between Mr. Purdy and Mr. Purdy's recanting of that previous
Sure.
state.
Yeah, I appreciate that. But again, a jury can believe that. There are cases where juries do believe that. And had that evidence not come in, they would have been deprived of the only statements from the alleged victim herself that weren't part of this clouded confession or not a confession that the jury was actually faced with. And I'll note in his closing argument, trial counsel, I think valiantly, tried to explain to the jury that they should, go with Mr. Purdy in what he had testified about the reasons for having made these statements. So even outside the corpus delicti part, although I think that is pretty key to this as well, if this, either way, if the evidence hadn't been admitted, Mr. Purdy, the jury would have reasonably acquitted him, or at least there's a reasonable possibility, or this court would have reversed on direct appeal on this, just that evidentiary basis.
So you appear to be making an argument that should we find in your favor, the result would not be remand for new trial.
So there's two alternatives, if you'll permit me, Your Honor. One is if the court agrees with me about the corpus delicti. So let's say that this evidence had been objected to, that the court agreed that it was hearsay, that it was inadmissible. Then the first of the Dern factors for corpus delicti with the alleged confession wouldn't have been met. And as the U.S. Supreme Court held in Opper, if you don't have that, if you don't have corroboration, that's the first and most important factor. And that's actually what this court said here as well. These unobjected to hearsay statements are the corroboration. If the court agrees with me that the corpus delicti argument would have succeeded, this court would have reversed Mr. Purdy's conviction outright without remand and would have discharged him because it would have been double jeopardy. I submit that if the court agrees with me here on the corpus delicti argument, then that would be the appropriate result as well. And Lafler, the U.S. Supreme Court says when there's a Sixth Amendment violation, we find the result that fits it most. And I think here the result would be discharged completely. Otherwise, though, if the court disagrees with me on that, we ask the court to reverse and remand for a new trial.
Thank you. And counsel, what I'm going to do is I'm going to invite you to take a seat because I think that the state's attorney has arrived. And welcome, sir. And counsel, what I will do is, Mr. Sternberg, I'll allow you a few minutes of rebuttal just because I know that you decided not to have rebuttal against yourself. So how many minutes of rebuttal would you like? Yeah, all right. You're welcome. I know that you just walked in, but we'd love to hear from you.
And my apologies.
Yes.
Again, apologize for my tardiness, Your Honors. Ethan Zipsigler from the Solicitor General's office. May it please the court. I think the first issue I'd like to address is generally the issue I'm on the back foot on, which is that I believe this court should find that this is not an issue that is preserved for an ineffective assistance of counsel argument in the first place. While I'm aware the state did not cross appeal this finding from the district court, I still believe this court has jurisdiction to consider it as the district court being correct in the outcome for the wrong reason. And that is the defense, frankly, did not do enough to establish that the failure to object in this case constitutes a problem that we can even address. The problem with raising failure to make a proper objection on hearsay at the trial level is that it invites us to play a game. It plays a game of, well, they get to keep the situation as stagnant as it ever was, and they get to claim error, but they don't get to have to address the second question, which is, well, what happens if they actually object? Well, if they object, the state can just call the witness anyways.
The witness in this case being the young girl.
Yes, the way they could have called the victim. And at that point, there is no hearsay issue. So there's no way of us to actually establish prejudice in this case because the defense has never established that if the state had been required to call this victim, they couldn't have produced this victim. In fact, they made the finding that the victim was available to testify, presumably because they wanted to make the
Well, I don't
objection.
understand how that would impact the prejudice argument by showing that the witness was available. I mean, we don't ever have to prove in the prejudice analysis that the other side did win, right? So the fact that the state could have called the witness and might have come, I mean, that's all very speculative, but I don't understand how that undermines the prejudice.
Because the whole point is that you don't get to just have speculation on what the jury would have done. If you object to both cases, the judge sustains the objection and then the witness never testifies, you should have to play out all the possibilities, which is that you object the second time, the district court grants the objection, you call the witness testifies, and then there is no hearsay issue. And we're not even here. My point is that this is different from an issue where we have a piece of evidence that is missing, which is traditionally what we have in the 1507, which is the most common is that the trial counsel didn't call critical witnesses, didn't call alibi witnesses, didn't call expert witnesses, didn't call some witness. And we know that we can look at what a witness testifies to at a 1507 hearing and say, do we think that would have made a difference to the jury? We can litigate that. And the state can call a rebuttal witness and the judge can say, well, looking at this witness and a rebuttal witness, do I think there's a difference? But when we're playing a game of pure hypotheticals where the dimensions of the trial could have changed at a second objection, they have to prove that the result would be different. But if the result of the objection being made the second time is the state says, okay, we're calling the victim, well, then there's no hearsay issue. And then you've got a real question as a defense attorney. Do I want this victim to testify? I mean, there are strategic witness reasons why you wouldn't object to hearsay here. There are very strategic reasons because you know the state's not calling the witness if you don't object. And you don't bring a 3-year-old in to testify in front of the jury when you've got a confession. And you've got to be thinking about the long game. Your client confessed to these crimes. And you're going to have to, at some point, argue that your client is entitled to a dispositional departure to probation, or not to probation, but to the grid from an off-grid crime. So a reasonable attorney in those circumstances may look at that and say, it is not worth objecting and making a 3-year-old testify.
Calculus that we look at a lot in these cases as far as objecting, even calling attention to the evidence more, et cetera, through the objection. I see what you're saying, but I think you didn't appeal that.
Right.
And so we should probably keep moving.
Yes. And my point is more,
Real quickly, counsel, on that question of a cross appeal, have you found any cases where we as a court or the Kansas Supreme Court has declined to consider a question in a 1507 for absence of a cross appeal?
I know from talking to co-counsel that there have been cases where the panels of the Court of Appeals have not addressed the merits of a state's claim that was not preserved by cross appeal, even with the argument that it was right for the wrong reason. I don't know what those citations are, but having talked to co-counsel, I believe they're out there, and I don't want to mislead this court in any way. As to the remaining arguments, I mean, the fallback argument is just these statements are not hearsay, and they are not covered by the Confrontation Clause. These are not statements made to prove the truth of the matter asserted. They're just statements that tell you why the investigators did what they did. They went out, they investigated because they got a report of sexual assault against a child. The disclosures by the police are minimal. They are not overly detailed. They just tell you why they are there. They
I
tell
know
you.
you weren't here for counsel's argument, but he pointed to the closing statement regarding the corroboration as being for the truth of the matter.
Sure. And I guess my biggest argument is that's statements of counsel aren't evidence, and that may have been prosecutorial error because he wasn't, the ruling of the court was these were not admitted for the truth of the matter asserted. So whether the prosecutor made those statements, those are not evidence. The evidence that came in was admitted to show the course of conduct in the investigation, and that's what the ruling was. And it's just not hearsay. There's another reason that it gets in, and that gets you beyond hearsay. And so the only other argument is whether it violates the Confrontation Clause. And as the cases show, it's going to be a rare case when a 3-year-old can make a testimonial statement. They're not making statements for the purpose of preserving testimony later.
Even if you're speaking to law enforcement officers?
I would say in that case, yeah. And I think here you're not I think these statements were made to a parent, and then the parent relayed those statements to law enforcement officers. So I think you're in it would be a different calculus. So I still think those are non-testimonial statements.
I wonder if you could address the corpus delicti argument that this undermines, in the absence of any corroboration as to the confession, it undermines the confession.
Sure. I think when you look at the corpus delicti argument, the only thing this changes is one piece of the calculus. It changes how you weigh the corroboration, but there's other parts of the calculation on corpus delicti that you're looking at. And here you have a fairly detailed confession. You have it after, going back and forth, the person's given opportunities and they repeat the story several times. Those all weigh, and what you're looking at in a corpus delicti argument is a weighing system of, do we believe that this statement has enough indicias of reliability that we don't need other primary evidence? And here, when you're weighing it, you have, again, a detailed confession. It's consistent through multiple times given. It doesn't really change. Once he's established what he says, which is that he slipped the finger in up to, I believe, the second knuckle, kind of repeats that. So you have a situation where this confession is reliable because of the other factors. And while if you were to find that the hearsay shouldn't have been admitted, there's some issue with one element of the corpus delicti factors, it doesn't actually mean that this statement wouldn't be admitted. It just means you don't weigh that factor in with the other factors. But there's really no evidence to suggest that the Supreme Court would have found it was corpus delicti without the statements of the child. It's just one more factor that they considered. And really, this court is in the same position now of saying, like, well, looking at the statement without the statements of the child, would we get to the same corpus delicti argument?
Does our analysis, and in the absence of those statements, does our analysis and weighing of that issue change in any way if you're just left essentially with Mr. Purdy earlier versus Mr. Purdy at trial?
I mean, yes, in the sense that one of the factors that the court weighed was that there were statements of the child and that evidence was admitted as part of the course of the investigation. So obviously, if this court finds that that testimony is inadmissible, which again, the state would argue it's admissible, so it could be considered. But if this court were to find that, you just don't factor that one factor, but these aren't mechanical weights. They're things you consider, but the ultimate question is just viewing this statement with all of the indicia of reliability and the concerns we have about just a statement made in an interrogation. Do we feel that this statement has sufficient indicia of reliability that it should be admissible? And again, the state argues that yes, even without the statements of the officer on their investigation, the statement itself meets all the factors and has sufficient indicia of reliability that this court would still find it was admissible and not corpus delicti.
Could you address also prejudice with regard to the rape claim or the rape conviction? It's my understanding that the conviction with regard to indecent liberties, there's a new trial that's been granted on that issue. So you're just left with the rape conviction. I'm curious as to why you believe the absence of an objection or the decision not to object, assuming that we're bound by that determination, is not prejudicial.
I guess I don't understand. I don't quite
With regard
understand.
to the Strickland analysis. Like you have to, Mr. Purdy would have to show that there was a deficient performance.
Right.
And that deficient performance was prejudicial. I was wondering if you could address the state's view as to why this is not this is not prejudicial.
I mean, I don't think it's prejudicial because at the end, first of all, I think the statements are admissible anyways. So it's not prejudicial because those statements come in regardless. They're not hearsay under the law. They don't implicate Crawford under the law. So they're admissible, and the trial would not have changed. If he had objected the second time, statements are still admissible. The only difference is that the Supreme Court does the analysis, which in retrospect, I wish the Supreme Court would have just done the analysis because then that saves us the 1507. But the Supreme Court did not say this is hearsay, but you didn't object, so we're sending it back. We're not reaching the issues of merits. And on the merits, the state still would have won, so there is no prejudice. And then I would also say that, again, you can't establish prejudice unless you can establish that the state couldn't have cured the hearsay issue at trial, and they've presented zero evidence that they could cure the hearsay issue at trial.
But do you have a cite for that proposition?
I don't, other than the just general logical, this doesn't come up that often. Usually we're not in the case where the claim of ineffective assistance of counsel is the failure to make trial objections. Usually it's failure to call witnesses, which we can definitively say that witness was available at the time of trial, that witness would have said this, and that's the impact it would have had on the jury. But here we're left in a complete unknown of, okay, you object the second time. What happens? Does the judge still overrule the objection and we go to the Supreme Court and they make a determination on the merits? Does the state say, you know what, I don't want to risk it, I'm calling the victim? Does the
Right, but we just get to sort of ignore the error because we don't know what could happen. I mean, the victim could have come in and recanted.
right? But
So then
that's,
that would have been just tremendous. So
yeah,
it feels bizarre to say there could absolutely be no prejudice because we don't know, because, the victim was technically available. We've seen lots of available witnesses that don't show.
but that's not my argument. My argument is that they have the burden of showing there was prejudice, which has an extra step in their case when they're saying failure to make a trial objection. Their burden is not just make objection, we win. It has to be make objection, we win, not just make objection. We win on appeal. It's at trial, nothing changes, and it's their burden.
I think there's a sort of a disagreement about what the second prejudice prong of Strickland requires. Does it require them to show they would have won?
It requires them to show a reasonable probability that the result would have been different. And that requires showing that there wasn't going to be some change in the evidence based on the second objection.
And that's the part that I'm curious if you have a legal citation.
I don't. It's just my argument based on Strickland and what the burden of the parties are. If the state had a similar burden, our burden at trial when we have to prove something beyond a reasonable doubt is often we have to disprove reasonable alternatives because it's not enough to say this could have happened. We have to show there aren't reasonable alternatives. It's not enough for them to say it could have happened this way. They have to show this is the way it most likely would have ended up and this is the result. And again, this is more my own. I just want to raise this because it's so unusual and I have a problem with trial objections becoming an issue for new trial in a 1507 when it essentially amounts to, well, what if, and we both get to play the what if game. But at the end of the day, the law is very clear. These are not hearsay statements. These are not.
And is that because you're saying they weren't for the truth of the matter asserted?
Correct.
Okay.
Yes, and they're not testimonial statements, so they're not.
And that is because you think it's the officers were testifying to the grandfather's statements and not to the victim's statement.
I think it's more the chain that comes from a 3-year-old making a statement to grandfather, and that statement, the statement they want to exclude, is non-testimonial. So it's not.
If the statement was from the victim to the officers, would that be testimonial?
I'm sorry, I don't know what my answer would be to that because I would have to look at the case law more in depth. But I think from my readings of the case law right now, it is when you have a child this young, it is very difficult to come to the conclusion that they were making a testimonial statement. And I don't think there's been any evidence presented by the defense to suggest that these were offered as testimonial statements. And at this point, it is their burden to show that. So I don't believe Crawford is implicated. These aren't hearsay statements. So there can't be prejudice because the trial was going to proceed the same way, even if there was a second objection.
Other questions, Thank you very much. Mr. Sternberg, you have, in a roundabout way, requested 3 minutes for
Thank you.
rebuttal. Give me just a second.
That's fine.
You may begin.
All right, I'll try to get through all this very, very quickly without speaking too quickly. Judge Warner, to answer your question, I have 2 cases where this court or the Supreme Court have declined to address a state's argument very similar without a cross appeal. State versus Novotny, 297 Can 1174. And then a Court of Appeals case from 2019, which Judge Gardner was on the panel, State versus Stewart. It's case number 119858 at page 8. And so there's that. As far as this what if game, I think I just heard the state's representative say that you can never have ineffective assistance of counsel for failing to make a hearsay objection and that we don't raise issues like that in 1507s. That's just not true. I do lots of 1507s and we deal with trial objections all the time. Failure to object to a jury instruction, failure to object to some question made of a witness, failure to object to hearsay.
Counsel, but isn't it true that if there would have been an objection, then it's not that then all of a sudden that statement goes away, then the state would have the ability to call the girl to come in and testify.
Sure, and that's what new trials are for. So under Strickland, the issue is under the circumstances. What were the circumstances then at trial? The circumstances were that the alleged victim was not there. The alleged victim was not called.
But the alleged victim was an available witness.
She had been deemed available by the district court, yes. And that was my client's trial lawyer's strategy because he suspected, there's a record volume.
But sometimes those strategies backfire, right? I mean,
Sure.
if she had been deemed an available witness, then that presumes that the state could have called her
Yes.
as a witness to testify, and thus the hearsay issue,
Right.
the confrontation clause issue, all of that goes away.
I agree, but here, Mr. Belville testified he was prepared if that was going to be the case. This is record volume 27 at page 43. He said that if she didn't testify, he was going to object to her statements as hearsay, but if she would testify, obviously he would have dealt with it. The issue, though, is that we don't have to show that she wasn't going to testify. All we have to show is that under these circumstances, the circumstances that in which the deficient performance occurred, that it would have prejudiced him. In fact, it would have been incumbent on, sorry, Your Honor.
No, go ahead.
It would have been incumbent on the state at our evidentiary hearing if they wanted to put on extra evidence of what they would have put on, what the circumstance was. This is what new trials are for.
Well, the state makes a good point that it's frequently discussed in these situations is, it's trial strategy to not object. And then you get two bites at the apple here by coming up with the 1507, right?
I understand that, but if I may, I know I'm out of time. Under these circumstances, that doesn't apply, and here's why.
Okay.
Part of the evidentiary hearing in a 1507 is for Judge Ward to make his own credibility determinations and determine what he believes, the witnesses are saying in front of him. Here, Mr. Belville was pretty adamant that this was his strategy. He was going to object to hearsay, and he just missed it with Detective Montag's testimony. And Judge Ward found that in his judgment. He had the right to do that, and this court has to defer to that determination of what he believed the strategy was going to be. The state can't pretend that he had some different strategy or some other lawyer could have had some other strategy. Here, his failure to object was not strategy, and Judge Ward had the right to find that.
I do have one question based upon something the state alluded to, and that is
Yes, Your Honor.
the Supreme Court's statement that statements by very young children will rarely, if ever, implicate the confrontation clause.
So I appreciate that's their argument. That's not true. So in their brief, they have this long sort of cite from a case that they don't even name. It's Ohio versus Clark. We mentioned it in our reply brief. In Ohio versus Clark, the Supreme Court of the United States didn't say that you can't have children making testimonial statements. There, the issue was statements made to someone other than law enforcement. Clark was about a statement made to a teacher and whether the teacher could testify about that in a trial. And the Supreme Court said that doesn't implicate the confrontation clause. There was no holding, as in the cases we mentioned on page 19 of our brief, that a child can't make testimonial hearsay. Here you have a child being brought to the police, making a statement to police, and then the police have, especially where this child was found available by the district court, you have the child then making statements through that police officer. That's testimonial.
Any other questions from the,
Not a question, but I did want to clear something up since we
Yes, Your Honor.
are reporting. It actually isn't this, the state's attorney, I think, just accidentally misspoke with regard to what Mr. Purdy confessed to doing earlier, and I just wanted to clear that up with regard to the level of insertion, et cetera. So,
You want me to address that?
no,
Oh,
I'm just clearing it up.
fair enough. Thank you, Your Honor. Thank you. We ask the court to reverse and remand.
thank you very much. Very interesting argument, and thank counsel for your briefs and for your arguments today. We'll take this matter under advisement and issue a written decision as soon as we're able. At this point, I know that there's some musical chairs that have to happen, but we'll call case number 127103 from Johnson County. Augie Bogina and Metropolitan Properties LLC versus 5700 Barton LLC and Scott Long. Would the parties please state their appearances?
May it please the court, Brian Smith appears on behalf of the appellants.
Thank you. Both appellants, sir.
Yes.
Thank you.
May it please the court, Kirk Robinson appears on behalf of appellee 5700 Barton LLC.
Thank you. And sir, you are not appearing on behalf of Scott Long. Is that correct? Are you aware, Mr. Long has represented himself in this case. Is he appearing at all today, or have you spoken to him?
I have, he was unable to this. And he did represent himself, let's say. Properly.
But you will not be presenting arguments on his behalf, except to the extent that they are coextensive with your own clients. Is that right?
It's my position, they are coextensive.
Okay, thank you. Thank you very much. Counsel, for the appellant, would you like any time for rebuttal?
4 minutes.
4 minutes are granted.
Not even sure I'll take my full
10 or 11 up front, but
But no one was ever, criticized for not taking the full time. But nevertheless, you have 11 minutes and you're welcome to begin.
May it please the court, Brian Smith on behalf of Augie Bogina and Metropolitan Properties LLC in this case. The reason both of these entities are named is that when the original real estate contract was entered into, Augie Bogina was the purchaser. And as the process moved forward, he formed this LLC then that would be the recipient. He is and was the sole owner of the LLC. They do not have claims that are separate, but they are contiguous to the case. We're here today because the trial court ultimately disposed of this case without holding any trial to hear evidence and weigh the credibility of any of the testimony or the underlying documents. The first claim that was disposed of was the fraud claim on a motion to dismiss. And so it wasn't even considered in the context of what are the depositions that lead up to it, what are those types of things. It was a motion to dismiss based on the pleadings. And obviously, when we plead a fraud claim, we have to plead it with particularity. One of the things suggested in the appellee's brief is what didn't even specialize or outline the damages. It doesn't require that in the statute. What it requires is the claims with particularity. And claims for one cause of action can be used to support another cause of action. So you can have a claim that supports a breach of contract or an unjust enrichment claim, and it can also support a fraud claim. They don't have to be mutually exclusive. Our position on this case on the dismissal is that the court unnecessarily dismissed this based upon that we had pled sufficient facts for a fraud claim to move forward. That doesn't mean we're moving forward into a trial, but it means at the pleading stage.
Counsel, were you pleading fraud, affirmative fraud, or fraud by silence?
So it developed in the case that through some of the emails specifically found in the record at volume 5, page 63 and 64, that the defendants knew that they were going to be required to do something to deliver marketable title and weren't going to do it. And so their attempt was to shift that burden over to us, which I'll talk about a little bit more in my argument. So it ended up being a fraud by silence, with respect to the Chicago title policy.
Yeah, can you explain that a little more? Is your allegation that the fraud is not telling that they weren't going to cure the judgment? What exactly, silence about what is the fraud?
That specific piece of information, because in the record, and this is where, without having a trial and looking at this stuff in context, it maybe where a court doesn't have the benefit of weighing all the statements of the individuals and like. But if the court will have in front of it, it already does, the record volume 5, page 63. This is email exchange on December 13, 2021 between Chicago Title and the defendant. And mind you, this is the second title company. This defendant, we had a title report that allowed it to close, and then it agreed by an amendment to the contract to remove this condominium, I'll call it deed restriction, on it. And then it did that, and the title company would not accept the form of it, which was a breach of a contract, because that was a first amendment to the contract. That wasn't this objection business that we get into later. So then, instead of trying to cure that breach, the defendant says, well, let's just switch title companies. So now we switch title companies. And now on the second
Not
title,
alleging that's the fraud. Everybody agreed to switch the title company to Chicago Title.
my client entered into an amendment to do that. And we understood that Mr. Long maybe knew someone at Chicago Title and would be able to get the title insurance taken care of. And what's interesting is that first title report doesn't list anything about this Beacon judgment that's talked about later. And the Chicago title doesn't mention anything about the condominium restrictions. It's interesting how the title companies both were not in unison about what were the
There was an
required.
agreement to get rid of the condominium restriction, which occurred when you switched to Chicago title.
Well, it did not, yeah, he could not convince the original title company to remove that from Schedule B, Section 2.
One.
It was a schedule, that's what was interesting. This was a Schedule B, Section 2.
Okay.
And
You moved to Chicago title.
yes,
And this other Beacon issue comes up. So when did the fraudulent silence occur?
on between the transactions and discussions between December 13, 2021 and the December 14, 2021. And that would be volume 5 record, or volume 5, the record page 63 and 64. On December 13, Mr. Long was asking if the title company was waiving the requirement that there be a satisfaction of the Beacon judgment. And he messaged Roger Daines, who was with Chicago Title there was a back and forth. He messaged him at 11:47. Mr. Daines messaged back or emailed back at 1:38. And he said the exam still has this in place. And what he indicates is in place is the satisfaction of that judgment. Mr. Long then the next day sends an email to the people involved, which includes Mark Bodine, who is the attorney for my client, and both of the real estate agents, and says, I'm working through the title impediments as best I can. There is one, the judgment from Beacon Acquisition, that I'm struggling with. Now, the title company said it's still a requirement for you to deliver marketable title to my client. It wasn't a exception. This was a requirement. And if you remember, our position is you have to keep in mind the contractual obligations. So my client has a contract with the defendant where the defendant agrees to deliver marketable title, fee simple, in the property, insured by a title insurance policy. And a title insurance policy is like a car insurance policy. That title commitment that you get is an offer to insure the title, subject to certain requirements being met, which is Schedule B, Section 1, and they don't insure Schedule B, Section 2. And our position along this case,
Counsel, I'm still struggling a bit with what was the fraud?
right here, he says, then he says, first of all, he's saying that he's still struggling with this issue. There's no struggle. It's the seller's
He's saying
burden.
he's struggling to get it resolved.
Right. And then he goes on and he says, basically that my client you can proceed to take the risk of the Beacon judgment, or you can back out of the contract. So then all of a sudden it's my client's burden to clear that off of the piece of property it's buying.
It seems like he's giving your client notice that he does not intend to resolve the issue. And what he is trying to get capital to do is to change it from section B1 to B2. Right? As an exception,
Trying to get who to do that?
capital title.
Trying
to get them to,
I think he's trying to show that the judgment's so old that it should not be an impediment to ensuring a marketable title fee simple.
okay, so is it your contention that him saying, I do not intend to clear up the requirement on Beacon is the fraud?
It's a breach, and the reason is a fraud. He's saying that he is still working on the issue. There's no work on the issue. I mean, they're not, it's a requirement. They're not waiving it. And he's the time for the expiration to come up still hasn't arrived. That, depending on if you go by December 6th or December 19. If you notice on the Chicago title, there was a initial and then a revised. The, under this cure objection, it either was going to expire on 12/26 or 12/29, depending on which date you're.
Counsel, if that's the fraud, this kind of not being entirely forthcoming about what he knew or at the time, what was the reliance? What actions did your clients take in reliance upon that statement?
Well, we relied upon the fact that he would deliver marketable title.
But that was before he had stated, look, I'm not gonna, these are the options that are on the table. I'm not gonna cure this deficiency.
Yes.
So once he made that statement, which is my understanding that you're saying that that was kind of the crux of this fraudulent act or omission, what was the reliance on that statement?
The reliance was then my client relied upon the representations that, oh, well, the other issues we can work out. And this issue you now can take over. You can either pay part of it, you can take the risk of it. He was trying to convert this into a Schedule B2. And that's not what it was. And our position is this objection issue doesn't apply to the Schedule B Section 1 items, because that's what the seller agreed to provide is marketable title. It has a insurance policy offer from a title company that says, we'll give you that and insure your buyer if you meet these requirements.
If they'd moved it to B2 though, could they have issued insurance on it?
Assuming there's no objection to it.
Okay.
Right.
So he still could have met the requirement of delivering the marketable fee simple title insured by Capital if this had been moved to B2.
Yes, what's interesting here, nothing was being done on this, right? And you'll note in the record, this thing was ultimately resolved without any payment of any money. I mean,
Okay, but did your client outlay any extra money after this December 13, 14 date in reliance on this fraud?
He's already done the zoning changes. He's already been in front of an expended he'd been on one of these planning commissions, new people. He had gotten this change.
Right, that was done before this fraudulent act.
Correct. And now he's ready to pay for the property so he can begin to move forward on his investment.
Okay. So
So it continually costs him money by the delay here in the attempt to shift. This attempt to shift is that's our argument against the summary judgment. Kind of ties in with all of this is that and I think I ran out of time.
No, you did, but it's partially our fault for asking questions.
Please, go ahead.
Yeah, was that the breach occurred before any argument that the contract could have expired. And the breach was the seller's refusal to abide what he had contracted to do. We're sorry it would have cost him $26,000 maybe to set an escrow, but you can deal with these types of issues.
Okay, so the breach, and I am interested in that, so I'm gonna ask you to quickly address that for me. The breach occurred on the closing date?
It would have occurred, it actually occurred earlier because he says, I'm not going to do it.
So
He's already announced, I'm not going to do it. And you can't shift it over to us just because you don't want to perform your obligation.
Okay, so assuming that, let's just assume that there was no objection. Your argument would be the breach occurred when he said he wasn't going to clear Beacon judgment.
And that's important because he can't breach the contract and then turn around and claim that it expired. The first to breach can't turn around and claim the benefits of the bargain,
Thank you.
if that makes sense.
Thank you,
Thank
Counsel. We've obviously allowed you to go over a little bit, but I'll still allow you 4 minutes for rebuttal. I'm just going to extend your
Extend our
opposing
same,
counsel's
sure.
time a little bit.
Thank you.
Okay? Thank you. Counsel, I'm going to give you another 4 minutes. So you've got 19 minutes. Now, once again, if you choose not to use the 19 minutes, we will not be upset, but you're welcome.
I'm almost certain I won't need that amount of time. Shall I wait till the timer
Yes,
hits?
please wait just a second, but. All right, you may begin.
I think I'd like to start with addressing where we left off with this fraud and what was the fraud. I want to make sure there's no confusion here because what I heard from counsel was the fraud the addendum has nothing to do with the Beacon judgment lien at all. The addendum has to do with the condominium declaration. Not only that, but that addendum says if the declaration is not removed, the parties, actually, why don't I just read it? The parties must agree to extend the closing or the contract will terminate. There was no extension of the closing date, but more importantly, the declaration was removed. So I don't understand where the fraud was, whether it's a firm.
At all, given, as you pointed out, that Mr. Long is not a party to the contract. So ordinarily with,
We'll do